I seek your lordship's indulgence in mentioning part 2, item number 3. My lord, this case is taken up by Mrs. Mary. She have requested me to adjourn the matter for 3 weeks. Yes, my lord. Yes, my lord. After 3 weeks.
My lord, item 7 of part 2, if it can be fixed for Tuesday next week, the 20th of January. I have taken the consent of the other party. Item 7. Obliged, my lord.
Lordship, we seek your indulgence in mentioning part 2, item number 8. That in this matter, the leading counsel is on holiday due to ongoing Bihu festival. And may it kindly be, the matter be listed after 2 weeks and petitioners. I have taken the of this party. Yes, my lord. 2 weeks. Blanche.
Admission, item 1.
It may please, Your Lordship. My lord, in this case, I don't think any pleadings are required. Unless my it's not yet admitted. It's for admission hearing, Your Lordship. If the matter may be taken up after 1 week, if possible, Your Lordship.
Your Lordship, if
The issue is very small. The only issue that is involved is whether amendment of the plaint can be allowed prior to the trial. Yes, Your Lordship. That is the only issue.
it may be taken up as an admission item, because Your Lordship, I would like to raise the question of maintainability. That is why.
Just for a week, Your Lordship.
After a week. Yes. Respondent number 1, my lord.
Three to 7.
Ms. Lilry Namit Sakswak for the Legal Aid Council, Mr. Durano Mingtanga. For respondent number 2. Lilry Namit Sakswak appearing for the Legal Aid Council.
No need, my lord. Much obliged.
Obliged, Your Lordship.
Next week. After a week, my lord. Much obliged.
Item 2.
May I please your lordship that the petitioner is the owner of a landed property located at Mualkhang, Kolasip district, And around the year 2020, respondent number 4, which is NF Railway, have occupied and damaged his landed property. And till now, no compensation was paid to the petitioner. And we are seeking for the to verify the land and
to file a similar order as passed in writ petition number 148 of 2019, isn't it?
yes, ma'am.
So have you received the instructions? This is simply to verify whether the petitioners are entitled.
Yes, Your Lordship, in this matter, I'm representing the district collector. And in this particular case, the district collector has nothing to do with this. So if there is
So if there's the
if
district
there is
collector.
order,
So similar order will be passed to verify?
Your Lordship.
Isn't it? Where's the judgment where you said a similar order? Is it attached here?
Yes, my lord. It's in page number 19, which is annexure number 6.
Okay, so what sort of order do you want? Please read out the operative part.
Okay, if I may take you to page number 21, which is from para
yes.
number 7.
Yes.
If I may, in view of the consent of the parties, the court is of the view that the verification team should be constituted. Accordingly, the Secretary to the Government of Mizoram Land Revenue and Settlement Department shall constitute a verification team consisting of the District Collector cum Deputy Commissioner Kolasip or his representatives, the Deputy Chief Engineer Construction NF Railway Silchar, some or his representatives, and the petitioner who shall verify the lands of the petitioner within a period of 1 month from the date of receipt of a copy of this order. The verification team consisting of the above persons shall verify whether the lands of the petitioner have been used by the respondent number 2 for constructing a road. If the answer to the above is found to be in the affirmative, the respondent number 2, which is the then respondent number 4, shall immediately take a decision within 2 weeks from the date of the site verification as to whether they want to permanently acquire the lands. If the answer is in affirmative, they shall make a requisition to the respondent number 1 and 3 for acquisition of the lands. Thereafter, awards shall be made as per the right to fair compensation and transparency in land acquisition, rehabilitation,
Okay.
and
Okay.
within
so
a
and
further
so and
period
so.
of 2 months.
So if they're not willing, they should stop using the petitioner's land, isn't it?
Yes.
Immediately, if not. Okay. Then then the last portion, read page 23. And the amounts so computed by the shall be paid.
In the event of the respondent number 2 is not willing to acquire the lands, the respondent number 2 shall stop using the petitioner's land immediately. In that event, the respondent number 1 shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 2, and the amount so computed by the respondent number 1 shall be paid by the respondent number 2 to the petitioner within a further period of 1 month from the date of the assessment made by the district collector, deputy commissioner.
Okay, similar order.
yes, Your
Okay.
Lordship.
Okay, disposed of and a similar order will be passed. Okay, yes.
Much obliged.
I'll give you the dictation later.
Item 3.
Yes.
My lord, the matter was called on September 15, 2025, and notice was issued.
Oh, yes. So counter if any.
Yes, Your Lordship, I'm seeking another 3 weeks' time to file my affidavit.
So this is basically
My lord, my land was,
solution and interest is not included.
yes,
So full amount will give you this thing to get instructions.
Yes, Your
You don't have to file your counter also, isn't it?
Yes, Your Lordship.
Whether solution and interest as paid for is entitled, or there's something where a payment has been made for solution and interest or whatever, isn't it? So you get instructions, and if it's required, you file your counter. If not, we can dispose
my
of
lord,
it.
the assessed amount
Oh,
was also not being paid in full. It was paid in a fraction
paid in
portion.
fractions. So how much is the amount still remaining?
There are multiple petitioners here,
Okay.
and
So you have mentioned that in your prayer
Yes, in
portion.
my, yeah.
Heard Mr. Simon Thanga Silo, Learned Counsel for the petition, along with Ms. Subhane Isiami, Learned Government Advocate for the state respondents. The Learned Government Advocate has prayed for further time to get instructions and file their counter affidavit if so advised. In view of the above, list the matter after, yes, 3 weeks.
3 weeks, Your Lordship.
3 weeks.
Obliged.
Orders, item 4.
May it please, my lady. I'm
Yes.
appearing through VC. Am I audible, my lady?
Oh,
Yes, sir. May it please, my lady. My lord, this is a 483 BNS's application in connection with Sessions Registration Case number 278 of 2023 under Section 21C of the NDPS Acts, my lords. My lords, this is an application wherein I was arrested in connection with 5.810 kgs of heroin, my lords. And my lords, all the other co-accused have been released on bail, my lord. I'm the only one who is still languishing, my lord. And as on today, my period of detention is 2 years, 7 months, and 2 days, my lords. My lords, I have also annexed the other bail orders, my lords.
so what,
at page
are you in the exact same situation as the others? Or there's some slight
my lord,
difference?
My lord, if I may draw my lady's kind attention to the seizure and arrest memo, my lord, at page
Simply
number
saying
21.
because the others have been granted, you should be also granted. How
My
is
lord,
your involvement and the involvement of the other 3? We have to see
I'm
that,
obliged,
isn't
my
it? Huh,
My
so
lady,
tell me.
my contention here is, my lady, my contention here is that if the arrest memo is perused at page 21, the grounds are same, that the grounds of arrest were not communicated to me, my lord. If my lord kindly peruses the second para, which starts from arrest was made, at page
Yes,
21, my
yes.
lords, has the arrest memo. May I read, my lady?
Yes, please.
Arrest was made in light of interrogation of accused person Muhammad Nazimul Hussain Borbhuya, who has been released on bail, my lord. Driver of the seized truck, who accused as the rightful possessor of the seized suspected heroin is Kutbul Alam Laskar, who is also on bail, my lords. Son of so and so. An arrest intimation was given to the respective relative of accused. Now, my lords, the grounds of arrest is that the co-accused Nazimul Hussain Borbhuya has implicated another person called Kutbul Alam Laskar.
So who are you?
Now the petition, my
Is your
lords,
name here?
I am Sukur Ali Mozumdar, my lord, number 2 accused. There
Okay.
is no mention of me in the arrest memo. So there are no grounds of arrest, there are no allegations against me per se, my lords. Therefore, prima facie there is no grounds of arrest against me. My whole arrest has been rendered illegal, my lord. And thereafter, that is further substantiated from the report of seizure and arrest, my lords have it at the next page. If my lords turns to page number 23, that is where my limited mention about my arrest has been made at page 23. If I may read the first para, my lord, from preliminary investigation. From preliminary investigation to the place of occurrence, I find that there are some more persons who were involved in this instant case on the same night at 2:15 a.m. I arrested Kutbul Alam Laskar, son of so and Sukur Ali Mozumdar. This is me, my lords. So and so. The accused Kutbul Alam Laskar is suspected of the rightful possession of the SA, and Kutbul Alam Laskar is the handleman of the seized vehicle, is the one who took out the seized suspected heroin from its concealment. Here also, my lord, there is no whisper about my involvement. My
Okay,
lord, there
what
are
is the
no
seized
illegal-
amount? What is the seized article?
My lord, the
was
seized
seized?
article is
5
mentioned as
kgs of
5.
heroin.
Yes, my lord, 5.180. But my lord, it has been clearly stated by the IO that the main persons who had handled it, or the masterminds, were Kutbul and this person called Nazimuddin, my lord, and Kutbul. So both of these people, my lord, who was the handleman and the driver of the vehicle, and subsequently who was held to be the mastermind, one Kutbul Alam, they have all been enlarged on bail, my lord. I have annexed the bail petitions. My lords will find the bail orders at page 54 and 67. And my lords was pleased to grant bail to the mastermind Kutbul Alam Laskar on 29/7/2025, my lords. If I may take my lords to the relevant portion at para number 11, my lords, at
Of
72 page number
Page
of this
72.
bail order of Kukul Alam, my lords.
72. Page
Yes,
number
my lords.
72, is it? Huh?
Yes, my lords, para number 11, if I may read.
Yes.
This court has, however, taken note of the fact that the co-accused in the case, Muhammad Nazimul Hussain Borbhuya, accused number 1, who is the driver of the vehicle from where the SA was seized and in his presence was granted bail by coordinate bench of this court on 14/7/2025 in bail application number 25 of 2025. Thus, applying the principles of equity and fairness, this court is constrained to grant bail to the accused a bail bond of 1 lakh with 1 surety and so and so. So, my lords, he is the mastermind, admittedly, and the other person, Nazimul Hussain Borbhuya, who was allegedly driving the vehicle, have both been granted bail. The first bail application, my lady, will have at page 67, where Kutbul Alam Loskur was granted bail. He was the driver, my lords. It starts at page 67. I apologize, madam. It starts at page number. It starts at page number 54, my lords. The bail order of Nazimul Hussain Borbhuya. A coordinate bench of this court had enlarged him on bail. If I may take my lords to para number 10, page 59, my lords, where the entire law regarding illegal arrest without furnishing the grounds of arrest were elaborately discussed by the learned coordinate bench.
Who's the
And from
accused
10,
here?
my lord,
What's the name of the petitioner here?
my lord, the name of the petitioner here
Nazimul
is
Hussain.
Sukur Ali
Is it?
Mazumdar.
Yes, Nazimul Hussain. Okay. So let's look at the
Yes.
memo of arrest. Memo of
My lords,
arrest is at
the
page.
petitioner for my lady today is Sukur Ali Mazumdar, my
Yes,
lord.
yes. So no, I want to see the involvement of this person, Nazimul Hussain.
Nazim.
So
My lords, may kindly
where's
come
the
to
memo
page
of
20.
arrest? Page
Page number 20, my lords.
21. Let's come back to
20
that.
is the
Yes,
arrest
let's
memo
come
of
back to
Nazimul,
that.
ma'am.
So here, two names have been mentioned, Nazimul
My
Hussain
lords.
and your Abdul.
Yes.
So,
Abdul Kalam Laskar.
yes. So Nazimul Hussain, the observation of the coordinate bench of this court is that grounds of arrest was not
Were not
mentioned.
furnished.
Is it?
Yes. Yes, my lords.
Well, anyways, that's okay. Oh, another. What else?
My lords, apart from that, even if we consider that on the basis of the statement of Nazimul I was arrested, my lords is aware of this settled position of law. My lord, I have served a compilation of judgment. If my learned colleague there could kindly share it with the court. Mr. James, I have handed over. Yes, my lords. My lords, if I may take my lady directly to page 132 of that compilation, I am relying on a judgment of the Honorable Apex Court in P. Krishna Mohan Reddy. Page 132, my lords. I have marked the page numbers in the compilation itself on the top right corner, my lords.
Anyway, 122 is which case?
My lords, 102, my lord. It starts at 102. It's P. Krishna Mohan Reddy, my lord, wherein the Apex Court has clarified that if a co-accused has made an exculpatory statement against the co-accused, the same will be barred by the Evidence Act, and no reliance can be placed on such a statement of the co-accused to reject a bail application, my lord. If I may take my lords to page number 132 of that compilation.
Yes.
My lords, serial number 9, if my lords has it. It's in Roman 9, down below.
122, that is para 42. Is it?
My lords, 132, my lords.
132, not 122. Huh?
132, my lords.
Okay, 9. Yes.
Yes, if I may kindly read. Although a handful of decisions of this court, such as Indresh Kumar Supra and Salim Khan Supra, have held their statements under 161 of the CRPC ought to be looked into by the courts at the stage of anticipatory or regular bail for the purpose of ascertaining whether a prima facie case has been made out against the accused and the nature and gravity of the allegations, yet the aforesaid rule only applies insofar as such statements under 161 were made by witnesses and not accused persons. A statement of an accused under 161 of the CRPC stands on a completely different footing from a police statement of a witness. My lords, my humble submission here is that.
Oh, yes. So next point, come to your
No.
next point. Then
my
the
lords.
next judgment.
Yes, my lords. The next
yes,
judgment is
grounds
the,
of arrest. This
judgment-
is on grounds of arrest,
Yes, ma'am.
isn't it? Yes.
My lords, Prabir Purakasan,
grounds of
Kumar, my
arrest.
lords, we will
Then-
discuss. Yes.
Then the
And my
third
lords,
one,
my
what is the
lords,
third
already-
judgment?
My lords.
The third judgment you're relying on.
Third judgment is Gurbakh Singh Sibia, my lord.
Yes.
Wherein the apex court in para 27 of
Oh,
the
what does
judgment,
it say?
my lord, you will find at page 92,
What
has
does it
stated
say?
that since there is always a presumption of innocence, my lord, especially in a trial, a person who is behind bars is not in a position to defend himself.
Oh,
Therefore, it is
okay.
important that he be set at liberty so that he can
Yes,
prepare his
yes,
trial.
okay,
for the
okay,
test of
fine,
the
okay.
And
Next,
as on today, my lords, I have been told that out of 14 PWs, 11 have so far been examined. And my lords, over this course of over 2 years, 7 months, my lords, the trial is going at a snail's pace. And after the PWs have been examined, my lords, I have to prepare my own evidence as well, my lords. Therefore,
so
it is
a long
pertinent-
incarnation is which case?
Yes, my lord.
Which
long
citation for
incarnation,
long
my lord.
incarnation? Which this thing? Serial number?
My lords,
Which?
judgment number 4 and 5, my lords.
Okay.
Ramlal versus State of
Ramlal
Rajasthan
and Mahindra. Yeah, depending on these two,
Yes, my
isn't
lord.
it? Okay, fine. Then
Yes, my
next.
These are the judgments, and my lords have already granted bail in BA number 41 of 2025, Abdul Kalam Laskar, which
Okay,
I
so you're
think
saying
has
that
subject my
parity,
reading.
principles of
Yes,
parity
parity,
should
ma'am.
apply. Okay, fine.
Yes, it's
I got your point.
These are the basic grounds, my lords. Once the arrest itself is vitiated due to non-furnishing of grounds of arrest, further detention, my lords, is not permissible.
Okay, fine.
That is my humble submission, my lords.
Yes.
Yes, Your Lordship. Regarding the rule of parity, Your Lordship, what I would like to mention is that parity is not an absolute right to be released on bail. So in that regard, I have one citation.
Yes.
Sagar versus State of...
Not absolute, huh? What is the citation? The citation?
Yes. (2025) SCC Online SC 2584.
2584.
Yes, Your Lordship. And the paragraph which I am relying is 13.7, that is in page number 7, from the second paragraph.
Yes.
In sub number 30, if I may read out.
Yes.
Parity cannot be the sole ground for granting bail, even at the stage when the bail application of a co-accused is allowed. And in para 14, next para, what flows from the above judgment which have been referred to only to the limited extent indicated above is that the High Court
1414.
14, next para.
Yes.
What flows from the above judgments which have been referred to only to the limited extent indicated above is that the High Court speak is one voice that parity is not the sole ground on which bail can be granted.
Okay.
And another point is that, Your Lordship, as we can see from the arrest memo, intimation has been given to him. And moreover...
But what is the arrest memo? How is his involvement shown in the arrest memo? Page 21, isn't it?
Yes, Your Lordship.
Where's his involvement?
It is not written exactly
His
in that
name is
way.
not mentioned,
Yes.
isn't it? From one person, and it's taken out from this truck belonging, the driver is this, so-and-so.
Yes, Your Lordship.
And deceased is supposed to belong to someone. So how is his involvement?
His involvement is
So
in his statement, Your Lordship.
Receiving an arrest memo without showing as to how has he been involved. in
Another
that
thing which
case.
I would like to rely is that as per Section 37 NDPS Act, Your Lordship, there is the twin condition has to be
Okay.
satisfied
Ah,
in order to
so-
be released
so-
on bail. And
So
Your
how
Lordship,
is he involved in this case? Huh?
in that case, Your Lordship, I would like to take Your Lordship to page number 39A. That is the statement of the applicant. Translation copy.
His statement
Yes, Your Lordship.
recorded before the, under
Before the
161.
police. Yes, Your
Ah.
Lordship.
Then,
So here he stated that he knew that it was
his
hidden.
statement,
Yes, Your Lordship.
recorded before, so.
Yes.
Anyways, yes.
My
Anything
lords,
else?
if I may kindly give a short rebuttal, my lord.
Which
If I
one?
may take my lords to the judgment of Mahindra from that compilation,
Ah.
at page number 100, my lords, just one point.
On what?
Page number
On
100
which
of the
point?
My lord, on the point that the rigors of 37 will accrue against the accused, my lords.
Okay,
In
section
that,
37,
Honorable
yes.
Ethics Court has clearly stated. Page
Para?
100, my lords. Para
Para
4,
what?
my lord, 4 and 5.
4 and 5. Yes.
Here, my lord, the apex court notes that the main accused has already been released, and my lord, in the fifth point, the fourth line, my lord, it starts from having regard.
Your Lordship,
Para five.
before he,
Para 5,
Which
my lord.
judgment are you referring to?
My lord, the judgment of Mahindra, my lord, page number 100 of the
Mahindra versus
compilation.
State of Rajasthan, isn't it?
Yes, my lords.
Ah.
My lords, para 5 of that order.
5, yes. Please read
Yes.
para 5.
If I may read from the fourth line, having regard.
No, it doesn't start with having regard.
My lord, my lord,
Mahindra versus
ma-
State of Rajasthan.
State of Rajasthan.
Okay,
Yes. My lord, let me read para 4 and 5.
4
It is
and
clear.
5, okay.
Yes, yes.
Your Lordship,
Learned counsel for the
before-
petitioner,
before
on the
that,
other hand,
let me
points out
complete my
that the main
submission.
Oh,
accused-
wait. The additional PP has not completed. I thought you have completed, huh? Yes.
Regarding section 37, I have one citation, Your Lordship.
Okay.
2025 SCC online SC 2440. Union of India versus Vijin K. Varghese. Para number
SC number? SC?
SC 2440.
2440.
Yes, Your Lordship. Para number 17. If I may read out.
Yes.
The High Court then, on the strength of those premises, recorded a finding that there exists reasonable grounds to believe that the applicant is not guilty of the alleged offense, treating prolonged incarceration and likely delay as the justification for bail. Such a finding is not a casual observation. It is the statutory threshold under Section 37, subclause 1, subclause B2, which would disentitle the discretionary relief and grant of bail must necessarily rest on careful appraisal of the material available. A conclusion of this nature, if returned without addressing the prosecution's assertions of operative control and antecedent involvement, risks turning upon appreciation of evidence which would be in the domain of trial at first instance. The court ordinarily shows deference to the discretion exercised by the High Court while considering the grant of bail. However, offenses involving commercial quantity of narcotic drug stand on a distinct statutory footing. Section 37 enacts a specific embargo on the grant of bail and obligates the court to record satisfaction on the twin requirement noticed above, in addition to the ordinary tests under the Code of Criminal Procedure.
Okay, what are the twin requirements?
That he has to prove that he is not guilty. If there is a presumption,
My lords,
the presumption is
if
there.
I may kindly clarify, my lords.
Yes, anything else?
No, Your Lordship.
Yes.
My lords, yes. Regarding the learned PP submission that the twin conditions are those, if I may kindly clarify, there are twin conditions, my lord. Firstly, that the learned PP has to be heard. And secondly, the court should be satisfied that prima facie from the records, the
That
accused has
is
not
not-
committed the crime.
Yes, yes.
These are the two grounds, my lords. And now, if I may take my lady to that judgment I was referring to, Mahindra, my lord. At para 4, my lord, it has been clearly listed, my lord, if I may read, paragraph 4.
Yes.
Learned counsel for the petitioner, on the other hand, points out that the main accused, Rahul, has now been released on bail by the High Court by order dated 17/5/24 passed in so and so. Next para, my lord. It is not in dispute that the petitioner does not have criminal antecedents. The petitioner was not found traveling in the car in which the contraband was recovered. It is also the same in my case, my lord. I was not in the truck. The petitioner has already spent 2 years in custody. The conclusion of trial will take some time. Having regard to the nature of allegations, it seems to us that the rigors of Section 37 of the NDPS Act can be appropriately relaxed in the case of the petitioner, as he cannot be incarcerated indefinitely till the conclusion of trial. This is the observation of the Apex Court. And my lord has already relied on these judgments in the bail application number 41 of 2025, and in case of a co-accused Abdul Kalam Laskar. Perhaps a copy has been
How many
provided to my lady.
prosecution witnesses are still remaining to be examined in this case?
My lord, as per my instructions, 11 have been already examined out of
No, so how many
14.
remaining? How many
Madam, three-
prosecution witnesses are yet to be examined?
My lord, that the learned PP would perhaps be in a better
Yes.
position, but so for my instructions are concerned, 3 more are there. But considering the snail's pace, my lords, it is unlikely it will conclude any sooner, my lord. And in the order dated 15/9/25 passed by my lords in case of the co-accused Abdul Kalam Laskar, if I may draw my lords' kind attention to para number 18, if I may kindly read. It has also been seen that this court in bail application number 29 of 25 dated 29/7/2025 had granted bail to the co-accused Qutbul Alam Laskar, who was said to be the rightful owner of the seized contraband substance, who was granted bail on the principle of parity. Since the co-accused Muhammad Nazimul Hussain Borbhuya was granted bail on 14/7/2025 in bail application number 25 of 2025. Does this court, considering the fact that the driver of the vehicle Ashok Leyland truck from where the contraband substance was seized was released on bail, along with the alleged rightful owner of the seized article Qutbul Alam Laskar, this court finds that the principle of parity would be applicable in the instant case, even though the accused is stated to have taken out the seized articles from the hidden compartment of the vehicle Ashok Leyland truck, since the allegation in the instant case is that the rightful owner of the said seized article as the co-accused Qutbul Alam Laskar, who was released on bail on 29/7/2025 in bail application number 29 of 2025. This court has also considered the fact that the petitioner has been in custody for a period of 2 years, 2 months and 6 days as on 29/8/2025, and there still remain 5 prosecution witnesses to be examined. Now, my lords, in this case, that particular petitioner was had helped the police discover those contrabands by taking out that secret box. So far, this present petitioner here is concerned, my lord, there is no allegations whatsoever. How he had been involved in this entire allegations.
Okay,
ma'am.
yes, yes.
Therefore, I am in a better position, my lords, I feel.
Yes, Your
Therefore, my
Lordship.
lords,
2
considering-
witnesses left.
And lastly, my
Out
lord,
of-
this
yes.
just one more thing I would like to draw my lady's attention. If my lady peruses the arrest memo once again, if I may take my
That
lords back to
you
page
have
number
already
21.
mentioned, arrest memo we have looked, okay, where your
My lord,
name
it's
is not
just the
mentioned.
grounds of arrest.
Huh?
But it's not just the grounds of arrest, my lord. Section 50 capital A of the CRPC, my lord, required that a arrest memo has to be attested by 2 independent witnesses, my lords. If my lords peruses the witnesses, they are the officers from their own department, the anti-narcotic department, my
Okay,
lord.
no civilian
So
witnesses.
they have,
Okay,
so
got
they
your
have
point.
been witnesses in their own case, my lords. Therefore, this is one thing that this honorable court perhaps cannot ignore. So, Lord, these are my humble submissions, my lord. I'll leave it to my lordship's wisdom. ma'am.
Okay, fine.
I'm so obliged.
I've heard both of you. I'll pass the order tomorrow. Okay, accordingly, you this thing inquire. Tomorrow the order will be out. Okay, yes.
I'm so obliged, my lord.
Your name is there in the cause list. What's your good name, please?
My lord, Orindam Borua, my lord. A. Borua.
A. Borua. Okay, the second. Okay, fine. We'll reflect this
Yes.
thing. It will be passed. Order tomorrow. Okay. Yes.
I'm so obliged, my lord.
Item 5 and 6.
Yes, my lord, I've filed my written objection. My lord, this is...
My lord, we received a written objection today. So we will.
What is this thing IE about?
My lord, the I is for stay which your lordship had
Okay,
granted.
impugned order. Destruction of buildings.
Yes, my lord.
Okay, fine.
My lord, we will be needing at least 2 weeks.
I heard Miss Emily L. Changte, learned counsel for the petitioner, who submits that, for the applicant, okay, who submits that he received a copy of the written objection filed by the learned counsel for the opposite party,
That's point number 5. Point number 5.
respondent number 5, only today, and has prayed for time to go through the written objection.
My lord, in the meantime, if the
My lord, since this matter was not being able to taken up last year, the lordship had granted stay to the petitioners, and my lord, the petitioners have conveniently moved back into their houses now. The houses which had
It
been
is
put
seen that
under lock and key.
Mr.
Rosang Zohra.
Rosang Zwala, learned counsel for the
Respondent number 5.
respondent number 5, has filed his written objection on 12 January 2025. In view of the above, as prayed for by the learned counsel for the applicant, matter is adjourned
Next week at least, my lord, please.
and to be listed in the next week.
my lord, in the meantime, if the stay order,
Is there an interim order?
yes, my
There's
lord.
a stay order.
Okay.
If it can
In
be
the next
continued.
week,
19th,
then
my lord.
the presence of Ms. Havani Isyami, learned government advocate for the state respondents, is noted. Respondents number 1 to 4 is noted. List the matter in the
My lord,
next
19th.
week as sought for on 19/1/2026.
Yes.
Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Part 2, item 4.
What is the matter about? What is it about?
Lordship, this is, we are actually having domestic relationship as husband and wife. So there was a problem in the year 2019, and the respondent is supposed to be my wife. Actually, though there was no proper valid form of marriage, and there was a dispute between the parties. And first, the respondent approached the village council of Kabbalah Nagar
So
number.
have you tried to settle the matter through this thing, Lok Adalat or mediation? Husband and wife? What is the dispute? Is it concerning? Okay, this is an RSA.
RSA law.
However, if the parties themselves have settled their dispute between themselves, then whether it's an RFA, RSA doesn't really matter. It need not pursue the matter. So, have you made any attempt previously to come to some settlement through some alternative dispute resolution mechanism?
No, Lord, Ladyship, there's not been any attempt. And regarding that, Lord, Ladyship, that they've even tried to settle the matter, but in fact, Lordship, they have even filed for the contempt petition regarding this case also, regarding the payment of maintenance.
Oh, it's maintenance.
And-
Then I think somehow you can come to some settlement.
No, Ladyship, the issue is that the appellant herein has failed to pay maintenance regularly, Lord Ladyship. Even the last maintenance was paid in the month of 26 January 2025 till the month of April. After that, it has not been paid again. And then in the month of September 2025, the husband has paid maintenance, not actually maintenance, just for medical expenses of 1,000 rupees, Lord Ladyship. So there has not been any proper maintenance of payment regarding the maintenance amount.
Okay, in the RSA,
Lordship, the issue is that even though it's an RSA, this Honorable Court on 8 October 2020 was pleased to grant maintenance to the children, as there were two children born between us.
Because legitimate or illegitimate children, they are entitled to the maintenance.
Exactly, Lordship.
Isn't it?
Yes.
So they're entitled, if they're entitled to maintenance, then why aren't you paying the maintenance? What is the main issue about?
Lordship, as far as my knowledge is concerned, we regularly pay the maintenance, but the thing which submitted by my learned friend, in fact, is required to be examined. Actually,
Examine, because whether their marriage was solemnized or not, that's not the matter here. It is if the children are born out of between the cohabitation of the parties, then the father is required to pay maintenance of the children.
Lordship,
So I think you should talk to your client and explain to him.
Lordship,
Find out,
that is the other matter.
Okay.
The main issue involved in this matter is very simple in the sense that, Lordship. Actually, my wife means that the respondent.
Your wife, so admitting that she's
Yes,
your wife.
even though it's the illegitimate. Actually, to be short,
Mother
let me
of
say
your children.
Yes. She approached the village council court stating that I used to assault her many times and made a specific prayer to save her life. That's the only prayer. And first, she approached Kalamandakar 2, village council. And some jurisdiction matters, the case was dismissed. And thereafter, she again approached Kamalanagar 1, village council, in which, after taking thorough evidence, the village council court decided that as the parties did not get married as per the Chakma Customary Law Code 1997, they could not consider the matter and dismiss again. And thereafter, the wife, the respondent, filed a regular first appeal to the district council court. The district council court totally traveled beyond pleadings, and the district council court divorced the parties, distributed their properties, and maintenance also. Now, challenging the particular order passed by the district council court as an RFA, I approached this honorable court.
So it's all very based on the technical technical defects which you feel is present in the order.
Lordship.
So in the meantime, who is suffering? The parties are suffering, isn't it?
Lordship.
So now you know that if the children are born out of the wedlock or between the cohabitation of the parties, then even if they are illegitimate under 125 CRPC, the old act,
Lordship.
still still has to pay the maintenance for the welfare of his children, isn't it?
Lordship.
So I think this is a matter which is very appropriate to be referred to either the Lok Adalat or mediation in the district, which is this is where
District Council Court, Kamalanagar.
Kamlanagar. So then the district legal services authority, of which this thing, they can take up the matter also, or because I'm just thinking the parties, will it be difficult for them to come to Aizawl?
It shouldn't be difficult, I believe. Lord.
It shouldn't
Yes.
be? If they can come here, it's very good. They can come here themselves. Then we can refer this to the mediation center.
Although, Lordship, if I may, I believe we have to consult with our clients first.
Yes,
regarding
yes. So the possibilities, okay. If you consult them, find out whether they want to have it referred to the District Legal Services Authority at the Saiha district, or they can come to Aizawl itself for settlement and persuade them to settle the matter. Because even if the matter is dismissed or whatever, or allowed, the problem will still continue unless they settle the matter. Once they settle the matter, the court did not interfere. It can be settled between both of them, isn't it?
In my belief, Siaha may be appropriate forum as
So
Aizawl is
find out,
quite-
find out,
yeah,
find
Lordship,
out.
Yeah, we'll
Find out whether they're willing to
Let
have
us
the
talk to
matter
them.
referred,
Yes,
isn't it? Yes. Heard Mr. Tilal Nunsiama, Learned Counsel for the appellant, along with Mr.
Samuel L. Patswao.
Okay, Samuel L. Pachow, Learned Counsel for the respondent. On hearing the submissions made by the learned counsels, this court finds that the subject matter in the appeal finds that this case is appropriate for reference to the Lok Adalat or mediation. Good stop. The learned counsels for the parties may inquire whether the parties are willing to have the matter referred for amicable settlement through mediation or Lok Adalat. Okay. List the matter after
A week.
A week, yes.
1 week. Yes.
Item number 10.
Much obliged.
Okay, part 2. So say part 2, I'll get lost now. Yes. So who's the counsel for the government advocates were here? What happened? Not willing to have the matter? Okay, Mr. Neitsung Adarlong, isn't it? Learned counsel for the petitioner is present. While none appeared for the state respondents. In view of the mock, list the matter after 1 week.
It's fine. Hold on,